This is not specific to the Second Amendment, but I want to make sure you understand exactly what's going on with this 14th Amendment insurrection argument, trying to keep Donald Trump off the ballot in these various states. This is important for you to understand because you want to understand all the Constitution and not just the Second Amendment, because our right to keep and bear arms is protected not just by the Second Amendment itself, it's also protected by the structure of the Constitution and the various checks and balances that work within it. So I want to talk about this 14th Amendment issue because it's been all over the news, and I want to make sure you know exactly what's going on so you're the smartest person in the room. And I'm in a suit today because, yes, I was on Fox News talking about this exact topic, so I figured let me elaborate for all you guys out there in the land of the Four Boxes Diner. Stay tuned. You're not going to want to miss this discussion of the insurrection issues, the Supreme Court argument, and Donald Trump. Hey folks, I'm Mark Smith, host of the Four Boxes Diner, proud American gun owner, constitutional attorney, member of the United States Supreme Court Bar, and author of Disarmed, What the Ukraine War Teaches Americans About the Right to Bear Arms. All right, folks. So, a lot in the news about the attempt by states. I think there's 14 lawsuits in the United States right now trying to get Donald Trump knocked off the ballot on the grounds that his actions on January 6, 2021 allegedly was an insurrection. And this is being litigated mostly in sort of blue states and some other states, but really the blue states to try to get him knocked off. The Colorado Supreme Court signed off on this notion that Donald Trump could be denied access to the ballot in a particular way. They did the remedy. At the end of the day, it wasn't going to work out that way. But nevertheless, Colorado did it, and the Maine Secretary of State effectively did the same thing. Now, this was argued to the U.S. Supreme Court just yesterday, and as I predicted, it went absolutely terrible for the anti-Trump argument that Donald Trump can be removed from the ballot and cannot run in certain states because he engaged in insurrection. This was absolutely terrible day for, I would say, the anti-Trump lawfare movement when it comes to this 14th Amendment argument. Just to jog your memory, under the 14th Amendment was adopted, as you know, in 1868. Why was the 14th Amendment adopted? Essentially, it was adopted to expand civil rights to the freed African American slaves, number one. And number two, it was also designed to cut back on the authority of states to violate various rights. So when it comes to the Second Amendment, the purpose of the 1868 14th Amendment was it extended, among other things, the right to keep and bear arms to the freed African American slaves, and at the same time, it applied the Bill of Rights, among other things, to these states and localities so they could no longer violate the Bill of Rights, which up until that point they arguably could, because the Bill of Rights originally in 1791 only applied to the federal government as a check on the new federal government. So with that said, one part of the 14th Amendment, Section 3, specifically talks about how for those individuals that engaged in a quote-unquote insurrection, which obviously is a reference to the Civil War in the mid-19th century, they were not allowed to hold certain offices, and that's a key word. Specifically, the 14th Amendment says as follows: no person shall be a senator or representative in Congress or elector of president and vice president or hold any office, that's key, any office, civil or military, under the United States or under any state who having previously taken an oath as a member of Congress or as an officer of the United States or as a member of any state legislature or as an executive or judicial officer of any state to support the Constitution of the United States shall have engaged in insurrection or rebellion against the same or given aid or comfort to the enemies thereof. But Congress may, by a vote of 2/3 of each house, remove such a disability. So that's the language of the 14th Amendment. And the argument was put forth by some scholars, a handful of scholars, that under the 14th Amendment, Donald Trump could be found to have engaged in insurrection on January 6, 2021, and the states could remove him from the ballot on the grounds that all of these states have some provision that says something along the lines of that no one shall appear on a presidential ballot in our state unless they are in compliance with all laws. And of course, the argument is that by violating Section 3 article of the 14th Amendment, the candidate, in this case allegedly Donald Trump, violated the 14th Amendment, Section 3, and thus he is not complying with all applicable laws, like in the state of Colorado or the state of Maine, to be eligible to be on the ballot, and thus he can be removed from the ballot just by the state acts. Now, this I explained, and you probably remember this from before, I predicted this is an absolutely terrible argument and it's going to lose 8-1 or likely 9-0. I stand by that prediction. I think the argument before the U.S. Supreme Court that just took place actually was worse for the anti-Trump movement, for people that wanted Trump removed. I think it went worse than anyone could ever have even envisioned, including myself, for a whole host of reasons. And I just want to spend a few minutes going through some of the main arguments that you're going to see in the opinions, explaining why no state can remove a presidential candidate, including but not limited to President Trump, from the ballot for running for the United States presidency. The first thing you're going to hear, as we talked about before, is that the precedent from the 19th century is that the only governmental entity with the legal authority to act under the 14th Amendment to remove the capacity or their eligibility to run for the White House is Congress itself. Because Congress has not acted to remove Donald Trump or prevent President from being able to run for the office again on the grounds that he engaged in insurrection, because Congress did not do that, it's game over. So that's the first decision you're going to see. The second thing you're going to see is a comment made by Chief Justice John Roberts that literally, well, you could hear him rolling his eyes almost at this argument by sort of the anti-Trump movement. Chief Justice Roberts says, I'm confused here. What you're saying is a single state like Colorado has the constitutional authority to remove an American who wants to run for national office on the grounds of the 14th Amendment. But then Chief Justice Roberts made the observation. He says, I'm confused here because the 14th Amendment adopted after the Civil War was specifically designed to, if anything, expand federal authority and reduce state powers to make sure that states did not engage in various mischief. So Chief Justice John Roberts pointed out that he thought that the argument that the 14th Amendment allowed states the power and authority to remove somebody from the ballot for the White House was totally inconsistent with the whole structure of the 14th Amendment, which again was about cutting back on state powers to make sure they didn't violate various rights. So it's pretty clear Chief Justice John Roberts thought this argument had no merit. Then it turns to Justice Amy Coney Barrett, and Justice Barrett was utterly perplexed as to how this might work, because she says that every single state has a different standard of proof, a different evidentiary standard, a different way in which you determine who gets on a ballot, who's not on a ballot. She points out that some states, like Maine, let the Secretary of State make the decision. Other states allow courts, like Colorado, to make a decision. Then she goes on to say that all of these different states have different evidentiary standards. For example, some states may allow in what's known as hearsay, which is a statement made outside the court, submitted for the truth of the matter asserted. I won't bore you with the details here, but essentially, if you look at the January 6th report out of the House, that would all be hearsay evidence that would be admissible in some courts, like in Colorado, but would be inadmissible as inadmissible hearsay in other courts and other jurisdictions. And Justice Barrett says this seems absurd that you'd have all sorts of different standards in all these different states, and any one of which could remove a person from the ability to, achieve national office to the detriment of the rest of the country. And she didn't seem to think that was going to fly. The other interesting observation was by Justice Brown Jackson. Now, Justice Brown Jackson was quite interesting because she said, as a matter of text, which is interesting how she embraces the text. She doesn't necessarily embrace the text when it comes to the Second Amendment, is my guess, but she embraces the text here. And she's like, look, the 14th Amendment talks about people cannot hold certain offices, but she's like, don't you think that if they really wanted to prevent someone from becoming the president, if they had engaged in this conduct, it would have actually said the word president in the 14th Amendment? And she points out that it doesn't prevent someone specifically from becoming the president. And she thought, as a matter of text, that the argument against Donald Trump could not fly. Then we saw other interesting arguments by, like, Justice Kagan, no friend of the Second Amendment movement, but Justice Kagan made the observation. She's like, how is it possible that a single state could decide a presidential election and remove basically prevent them from being president? And then, of course, there was discussions by several of the justices that made the observation, well, once basically what they were saying is, if you allow the Democrats to remove President Trump from a quote-unquote insurrection on January 6th in certain states, nothing is going to prevent the red states, the Republican red states, from removing a Democratic candidate on the grounds that that Democratic candidate either engaged in insurrection or possibly, keep in mind, there's another clause here in Section 3 of the 14th Amendment that talks about or has given aid and comfort, aid or comfort to the enemies thereof. And, Justice Alito made this specific question. He specifically says, well, let me get this straight, counselor. So what would happen if a president gave money? This is going to sound a lot like Joe Biden giving money to Iran, by the way. Listen to the hypothetical. Justice Alito says, what would happen if the president gave a lot of money to a nation that undeniably and repeatedly had stated that they were an enemy of the United States? He says, does that mean that certain states could remove that president from the White House or prevent them from running on the grounds that they had given aid and comfort to our enemies? He says, why couldn't they do that? The point being, all of this goes back to the notion that if any single part of the American governmental system has the authority to remove someone's eligibility to run for the White House, it's Congress. And that is consistent with something that Justice Kavanaugh talked about. He talked about, and we had talked about this before in a prior video, the Griffin case from the 19th century, where eventually Justice Chase, but we won't bore you with the details, he was a judge on the circuit court at the time, but in a case called the Griffin's case, Justice Samuel Chase said that this is all about Congress. The only people that have the authority to effectuate Section 3 of the 14th Amendment is Congress itself and no one else. And Justice Kavanaugh seemed to say, yeah, that is clearly the case. And the last observation was a couple questions from Justice Thomas. He really pushed the lawyer representing the voters in Colorado, and he basically says, look, we've had all this time since the adoption of the 14th Amendment. Certainly someone somewhere has been denied the ability of running for federal office on this grounds. Can you cite to a single example where someone was denied the ability to run for federal office based on this argument, and the lawyer for the voters was not able to identify one? He was able to point out that there were some state officials under the state law that could not run, but no federal candidates or no federal officials were denied the ability to serve in the federal government under the 14th Amendment. And that was something Justice Thomas hammered home on. The last point that I thought, again, I'm giving this to you because I think you sometimes like this intellectual geeky stuff. The last really geeky point that was made by the justices was, what happens if a president engages in an insurrection or aids and comforts the enemy while he's the president? Because the argument, and this is just stay with me for 1 second. The argument went this way. They said, look, if you're the president and you engage in insurrection on day 1, and then on day 2, if you argue that the 14th Amendment Section 3 is self-executing, meaning that once you engage in insurrection, you are automatically ineligible to be the president with no act of anybody. The justices said if that's the case and someone is already the president, then they engage in insurrection and they are still the president, then if you think about what that means, it means after they've engaged in that alleged insurrection, if it's self-effectuating, it means that anything they do after that date, they are acting ultra vires. They lack the authority to be the president. And then the practical question came up in argument that says, well, if that's the case, that means the entire federal government will have no leader, because if you have a president elected who is swore an oath of office, he's the president, there's an insurrection that occurs, he participates allegedly in it. The next day, because of the self-effectuating nature allegedly of the 14th Amendment, he's no longer has the power to be the president because he engaged in insurrection. It means you have no president of the United States, and everyone that works for that president in the federal government can simply ignore what he or she says or does. And the justices were just like, yeah, that is absurd to think that scenario could take place. The only way that could conceivably be effectuated, again, is through an act of Congress, which also is consistent with the notion of the impeachment clause that says that Congress, of course, the House has the ability to impeach a president, and the Senate has the ability to convict and to remove that person from the White House. The last point I want to make is an interesting observation by Justice Alito. The argument was being made against the Trump campaign that, look, we don't have to worry. This is really a one-off. That Donald Trump engaged in this insurrection on January 6th. This is really unusual. We don't really have to worry about the precedent we're set here for Section 3 article of the 14th Amendment, because it's just never going to come up again. And Justice Alito says, basically, look, you can't say that, because for over 100 years after the Civil War, we really had no president was ever impeached. And then he points out that barely since the Clinton impeachment, we've had 3 impeachments. So he said the fact that this issue has not come up in the past does not tell us that it won't come up in the future. So yes, it's very important for the Supreme Court to, set the rules here. So what's going to happen here? It's going to be 8-1, probably 9-0, I think, that Donald Trump can be on the ballots. No state can knock him off. I think there'll be a series of concurrences. There'll be a whole host of reasons why this 14th Amendment argument brought by sort of the anti-Trump movement is an utter failure. I think there'll probably be a solid 10 or 12 powerful reasons why this is the case, exactly what I predicted. Who knows when this decision will come out? I suspect it'll come out in June, but only time will tell. But it's pretty clear that Donald Trump's going to win this one. And as to what happens after that, anybody knows? Nobody really knows. I certainly don't know, but we'll see what happens this year in 2024, and hopefully it all works out for us, because 4 more years of an anti-gun president is not going to be good for the federal judiciary, for the gun movement or the Second Amendment in this country. But we'll see how this all plays out. So there you have it. I hope you learned a little bit something here about the 14th Amendment, Section 3, the Insurrection Clause, and what it may mean going forward for President Trump. And don't forget to subscribe and resubscribe. Make sure you follow me on X at 4boxesdiner, and we will see you again soon here at the 4 Boxes Diner.
Orders up. Table 2A.